Sir, namaskar.
Namaskar. What is constructive notice?
Sir, if it is, sir, may I give an example, sir?
Yes, you give.
Sir, if the law requires the document to be registered, and if it is registered as per the Registration Act, then the contents give a constructive notice to the parties to it.
Any other fact which will be treated as constructive notice?
Yes, in case of negligence also, or if the party abstains himself uh, from an absolute inquiry, if the fact could have been discovered by an inquiry, then in that case also it will be treated as a constructive notice.
These two things, no other thing.
Inquiry or negligence, if it is registered, if the law requires it to be registered, then in these cases it can be served as a constructive notice, sir.
How to prove the contents of a document?
The contents of a document has to be always be proved by a primary evidence or secondary evidences.
Which facts should not be proved?
As per
Which
section
facts
58
will not be
of
proved?
As per Section 58 of Indian Evidence Act, facts admitted need not to be proved.
When previous judgment becomes relevant.
To prove the res judicata or the double jeopardy concept, the previous judgment is relevant under Section 40 of Indian Evidence Act.
When the court will take the opinion of an expert to prove a particular fact.
So general opinion is not relevant, but if the person is having a special skill in the field of foreign law, science and arts, then in that case, court can take the opinion of an expert. Or in case of proving an handwriting also, the opinion of expert can be considered.
Who is an accomplice?
Accomplice is given as per section 133, the person who is a co-accused in the case, and his statement can be a sole basis of conviction.
Can there be conviction solely on the testimony of an accomplice?
No, sir, as per the Bhuvani Sahu judgment, there has to be a corroboration before relying upon the statement of a accomplice. This is the rule of prudence, sir.
Why rule of evidence? Is there any, if there is any other section regarding accomplice?
Yes, sir. Section 114, illustration B talks about that if you cannot solely rely upon the testimony of an accomplice, there has to be a corroboration beforehand.
What is privileged communication?
Generally, these are certain kind of communication which are protected under Indian Evidence Act. Though they are relevant, they are not admissible in a court of law. For example, the communication between husband and wife, an advocate or his client, or if the fact concerns the security of a state, in that case it is not as admissible in the court of law.
Can there be conviction basing on sole testimony of one a particular witness? One witness only.
Yes, sir, there can be a sole basis of conviction. As per number of witness doesn't matter, it is the value which appended to it should matter.
What is leading question?
The questions which are self-suggestive of answers, which suggest the answer, the question which suggests the answers are the leading questions.
Whether leading question can be asked in examination chief.
Sir, they may be asked. In general, it shouldn't be asked, but if it is asked, then it has to be with the permission of the court, or the other party should not object to it.
How the credibility of a witness is to be impeached? Who is a hostile witness?
Uh, the party which produced his own witness, if he deposed a fact which is adverse to the party who brings it to the court, then in that case the witness is called as a hostile witness.
Whether the testimony of the hostile witness is to be totally ignored.
No, sir, it shouldn't be ignored. So, as per the rule of the separating the grain from the chaff, we can collect the relevant piece of evidences which are relevant to the case. In that case, it can be relied upon.
What is circumstantial evidence?
If in case of if there is no direct evidence available, then in certain cases we have to rely upon the circumstances. That means
What is,
which the circumstances of a case, the fact, the evidences can be collected from the circumstances. It has to be uh, the Pankaj Sadachara guideline, the Panchashil guideline, which is given in a landmark judgment that it has to be conclusive in nature. The parties to it must prove that the accused himself is guilty. It shouldn't concern any other third person. Then in that case, circumstantial evidence can be relied upon.
can there be a death sentence basing on circumstantial evidence?
Yes, sir. If it is formally established, then in case of circumstantial evidence, no, in general, death sentence cannot be relied upon. As per Supreme Court guideline, death sentence cannot be relied upon as circumstantial evidence.
What is actionable claim?
So, actionable claim is an unsecured debt other than hypothecation, place, or mortgage, and which can be transferred and doesn't it should be liquidated. Actionable claim should be the liquidated amount. Unliquidated amount cannot be treated as an actionable claim.
What is unliquidated amount and liquidated amount?
So, unliquidated damages means it is specified in case of contract. If there is any breach, there is an express provision that in case of breach or any other non-fulfillment of the contract, certain amount should be paid. It is prefixed by the parties. But unliquidated damages, it can be decided as per to the discretion of the court.
Whether charge can only be created only by contract.
In case of torts also, sir, uh,
I'm asking this question basing on the transfer procedure. Whether charge can be created only basing on contract.
not necessarily, sir.
What is the Ireland versus pressure rule?
This basically talks about the principle of strict liability. In case of whoever using the land for a non-natural purpose and or brings a dangerous thing to his own land, if that dangerous thing escapes and cause injury to any other person, that person is should be solely liable for the damage caused to the other party.
What is absolute liability?
So absolute liability is a new concept as per in which was evolved uh, by the Supreme Court of India. There is where the person brings or anything who brings a substance which is inherently dangerous. In that case, if that thing escapes and causes damages to any other person, irrespective of the exceptions available in the strict liability, the person should be held solely liable for the escape and causing damage.
What is voidable marriage?
So, as per Section 5 of the Marriage Act, there are certain conditions upon which a marriage should be made, and if the parties to it are not of a competent age, that means the boy should be above 18 years and the girl should be above 21 years of age. If they are not uh, in a particular within the particular age, then such marriage can be treated as a voidable marriage. And also, if there is insanity, then also due to recurrent attack of insanity, they cannot give consent to this marriage. Then in that case also, that marriage can be treated as a voidable marriage. That means can be treated as a void as the option of the parties.
What is the right of a child born through void and voidable marriage?
So as per the Hindu Marriage Act, they should be treated as a legitimate child.
Only legitimate. No, what are other right, property right?
They can inherit the property as per like a legitimate child can inherit. So the illegitimate child also can inherit the child born out of a avoidable marriage.
What is co-personal property?
The co-personary property is an ancestral property. It only consists of previously it only consists of up to three generations of up to four generations of male members of the family only. Now, as per after 2005 amendment, female members also can be treated. Daughters, to be very specifically, daughters can be treated as a co-partner to the property.
Five persons they assembled for committing docaity. Did they commit any offense?
Yes, sir. As per Section 399, preparation and dacoity is punishable at the all the
Simply
four
they are
stages of the crime.
not preparation. My question is they simply assemble.
As per Section 402, also, sir, they can be punished.
What is docaity?
Sir, when five or more persons assembled or they form an unlawful assembly to commit robbery, then it is said that they have committed dacoity.
What is criminal breach of trust?
The criminal breach of trust is given under Section 405 when a person is entrusted with the property and he subsequently converts or misappropriates the property for his own use. Then in that case, it is said that criminal breach of trust has been committed.
X saw Y was being taken by a tiger. He, in order to save Y, fired from his gun. In that event, Y died. What offense X committed?
So here X had committed no offense because his whole sole object was to protect the person. Uh, as per in general exception, the act is protected. He can take the defense of general exception.
What is legal disability under the Limitation Act?
If the person is suffering from insanity or minor, or if he is a minor, then in that case, the period of limitation will stop to run.
Okay, I'll give my feedback after the interview by second panelist.
Thank you. Sir, namaskar.
Namaskar. How are you?
Fine, sir.
Fine. Okay. Yes. Can you introduce yourself?
Sir, my name is Badrinath Biswal. I have completed my BSc in Chemistry Honors from BJP Autonomous College. Then after I have completed my 3-year LLB from Utkal University, right now I'm pursuing my LLM from Utkal University.
What is your specialization?
Right now there is no such specialization allotted to us, but I think, sir, I will choose for criminal law.
Criminal law. Why?
Yes, sir.
Why criminal law?
Sir, I have a special inclination towards the subject.
I mean, is there any specific reason?
No, sir, I think it will be helpful for my academics or to understand the law in a better sense.
Okay. So when you talk about criminal law, then uh, what are these statutes primarily you want to focus in criminal law?
To be very specifically, sir, IPC, CRPC, and Evidence Act.
Okay. So can you say that Evidence Act is a part of criminal law?
Sir, it is a part of procedural law which uh, governs all the criminal relating to procedure.
Okay. So as you are inclined towards criminal law, in a criminal trial, what is the criminal jurisprudence that is being followed by the courts while
First of
punishing? Yes.
Sir, first of all, there is an inherent presumption that the person is innocent until he is proven guilty. And the principle of natural justice also has to be taken care of while committing the trial.
Okay. So, if this is the criminal law, are you are you aware about a statute called Prevention of Money Laundering Act?
Sorry, sir, I know it superficially, but not in detail.
Okay. So then, can you say about is there any difference in general jurisprudence of criminal trial and PML Act? Any difference?
Uh, Sorry, sir, I can't say that.
Okay. 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 There is something called inherent jurisdiction of courts, right?
Yes, sir. Yes,
So,
sir.
do you think any criminal court has got any inherent jurisdiction? If yes, then which provision deals with it?
Sir, as per Article 142, the Supreme Court has inherent jurisdiction to dispose to deal with any case.
Okay. Any other provisions?
Sir, as per section, I think in 482 also under for section 482 also High Court can take cognizance of offences.
Take cognizance of the offences.
No, sir, they can
Okay. Acha, in civil side,
issue
is there
appropriate
any
orders.
provision? ah, all right. In civil side, is there any provision for provision which deals with inherent powers of the court?
Sir, section 151 of CPC talks about it, and section 9 also uh, talks that if the case is purely of a civil nature, then the all the civil courts have jurisdiction to try the case.
Okay. Can you tell us the provision for amendment of pleadings?
Yes, sir. Order 6, Rule 17 talk about amendment of a pleading.
And what are the conditions to be fulfilled? Or what are the tests in order to amend, which is being put to allow an application or reject an application for amendment?
Sir, the sole consideration should be if it involves a real question in controversy. In order to ascertain the real question in controversy, the court can allow the pleading to be amended, and it has to be done prior to the trial.
Trial means, as per
Before
you,
the commencement of the
trial
trial, before the
when the
commencement of the trial,
when the trial is set to be commenced.
sir, the trial is set to be commenced after the framing of issues.
Okay. Can you explain review, revision, and reference?
The reference is there in order to check the validity of an act, ordinance, and order. If which it is if it is necessary for the disposal of a case, then the court may uh, ask for the suggestion of high courts. It is called as reference, and revision is a jurisdiction under which the High Court and Court of Session can call for records to examine the jurisdiction of the court or jurisdiction of a case to ascertain whether if the jurisdiction is used in excess, or if the court is legally competent and he is not exercising the power to check upon that, the High Court or Court of Session can call for the records. And in cases of review, it solely lies with the court. If there is no appeal is made, then there is no appeal is made, or if so, if there is an express provision of appeal and the parties need not prefer an appeal, then in that case the court can review its judgment.
When suppose the parties are interested to file a review, file an appeal, but in that case, sorry, I'll rephrase the question. Suppose the parties are interested to file appeal. That means, as per your answer, they will never be allowed to file a review.
No, sir. If the suppose the limitation period of appeal has been exhausted, then in that case they can be allowed, even if there is a statutory mandate that in case of if there is an appeal, then there is no bar that they cannot
Then what
institute
is
a review
the
case.
is there any limitation for filing review?
Yes, sir, there is a limitation period given under the Limitation Act.
What is that period for review?
Sorry, sir, I cannot recollect that.
Okay. Uh, do you have got any idea about acknowledgement of liability?
Under Limitation Act, yes, sir, there is an effect of acknowledgement of liability. If
Yes.
uh, if the party acknowledges any date, a fresh period of limitation commences to run from that date when he acknowledges that.
Okay. Now you are the presiding officer of a civil court. You issued notices to other side. The defendant did not appear on the first date, right? And
Yes, sir.
in the second date also it did, and you gave another opportunity, it did not appear. Even those notices are sufficient. What would
Okay,
you
sir.
do?
Sir, Order 9 specifically deals with these such kind of scenarios. I will not straight away pass an ex parte judgment. I will first mm, order for an ex parte hearing, and after that I will um, try the case accordingly.
No, you may think about it again. This is a notice stage. Notice was served. They did not appear. Whether you will follow the procedure or you will directly hear the matter and pass the judgment. You are talking about ex parte judgment.
So the case is at notice stage.
Yes, notices were sent. In the first date of
Yes,
appearance and the second date of appearance, they did not appear. The defendant or one of the defendants did not appear.
sorry, sir, I will not be able to answer that.
Okay. So, is there any difference between a judgment and an order?
Yes, sir. Judgment is a final adjudication of a after deciding the going through the merits of the suit. Order is there can be many orders in a case, but judgment there has to be only one.
And what about decree?
Decree is followed by a judgment. Decree is a formal expression of an adjudication. After concluding the pronouncement of the judgment in a specific format as given under CPC, a decree is drawn up.
I'll go back to the previous question. So, in case of an ex parte order and in case of an ex parte judgment, can the defendant who has not appeared, who has been set ex parte, has got any legal recourse to again come back to the list and participate?
Yes, sir. He can file an application to set aside that order, ex parte order.
Do you remember the provisions?
Sir, if I'm not wrong, it is Order 9, Rule 13.
That is for setting aside the ex parte judgment or order.
Or Rule 13, I think it is judgment. There is a Rule 7, I think it is to set aside
Okay,
the order.
okay. Now, there is, let's say you are staying in a place where there is a forest land and there is a small forest, okay? And some people always create nuisance either by cutting the trees or by making some illegal activities in that your nearby your residential area or residence. What, as a lawyer or as a legal expert, what would you suggest to prevent, and how will you address to that particular issue?
Sir, I can bring a suit as per CPC uh, where the leave of the court is required, or at least two persons of the locality can can be made parties to it
What would be the prayer in the suit?
to grant an order like injunction to check those illegal activities to create public nuisance to stop the public nuisance.
Okay. What is the role of executive magistrate? And where, I mean, which provisions of the law deals with powers and functions of executive magistrate?
This is dealt in CRPC, where in CRPC, the power of executive magistrate to keep the peace and security for good behavior and peace can be taken by the executive magistrates. Apart from that, also section 144 and 145 is there to prevent any kind of breach of peace. If there is any kind of breach of peace is there, then executive magistrate can pass an appropriate order to that effect.
Okay. Suppose you you have done really well in the written examination and in the viva also, but somehow other you are not able to join the judiciary as, service as such. And what would be your plan for the next year?
If I see no reason of not getting selected this year. If there is any uh, misfortune happens, then I will definitely look upon my weaknesses and work upon it, and I will again appeal for the exam, sir.
All right. Thank you. Thank you.
Yes.
Let me give you my feedback. Constructive notice. Notice means a person who knows something or is aware of something, that is notice. Constructive notice is possession of a person is constructive notice, or is willful absent, he could not do. As a reasonable man, he would have made inquiry, and by such inquiry he would have known it. If he doesn't make an inquiry, then that will be as if such fact is known to him. That is constructive notice. By law says that it is known to you. Similarly, registration is also a constructive notice. When a registration, because a person who deals with a movable property, he must inquire before the sub-register office what are the transaction in respect of that property. So registration, this, and possession and willful absence, three grounds. Three are constructive notice. Facts admitted, section 50, facts admitted need not be proved. Then public document, probably I didn't put this question, you should go that section 74. That is that public document or all acts or record of acts of the official bodies, tribunals, government, etc. That you will note. All other documents are private documents. Previous judgment is relevant not only for res judicata, even also criminal case also, for doctrine double jeopardy. Doctrine jeopardy are when the court will not entertain that suit for the second time, previous judgment. Then opinion. Opinion, when the court has to form an opinion on any science or any foreign law or any art, then he will take the help of the expert. Expert means a person who is specially skilled in the subject. Accomplice has not been defined in the neither in the CRPC or in the Evidence Act, but who has taken part in the crime. You have to always remember 114B and 133. 133 says a conviction is not illegal because it is made due to by the uncorroborated testimony of an accomplice. But 114B says accomplice is unworthy of credit. Court may presume. So both the sections are taken together. So it is prudence, some amount of corroboration is required to accomplish evidence to record a conviction. Yes, those two sections are to be read together. Then accomplish those two sections instead of saying then privileged communication, those communications which are made to given not only to the advocate, these official communications, 126 to 129, all are privileged communication. Those are not to be disclosed before the court. Conviction on basis of conviction basis of sole witnesses can be done. Leading question cannot be put in cross examination if objected. Always it is put in cross examination. Even in the examination that can be put. Then credibility of a witness can be impeached by affecting his character, that is there. by affecting his kind of any other that he is not trustworthy. Credibility. Hostile witness means a person who does not support the person who has brought him to the court to give evidence on his behalf. That is hostile witness. Then hostile witness, as because a witness is hostile, his entire testimony should not be thrown away. Some materials if are coming, those are to be relied. Circumstantial evidence, circumstantial evidence is the indirect evidence, which is given when in absence of direct evidence, circumstantial evidence are indirect evidence to which are accepted, and if it is joined in a chain that points against the accused conclusively that he has committed the crime. So that is conclusive proof. Conclusive. That means the chain must be so connected that it points to the accused that he is guilty. This is circumstantial evidence. Normally, death sentence is not given based on circumstantial evidence. Charge means what? Charge if a immovable property by act of parties by operation of law made security or for payment of any money which is not a mortgage or hypothecation, that is charged by operation of law or by act of parties. Then a immovable property of one person is given in security for payment of money, and that is not neither a mortgage nor a hypothecation, then that is charged. Actionable claim into any debt other than the debt secured by mortgage or hypothecation, which the civil court recognizes as a ground to give relief. So liquidated, unliquidated limit, that is not to be applied in case of actionable claim. Actionable claim to any debt other than debt secured by mortgage or hypothecation, that is created by act of parties or by operation of. Then Ryland versus Fletcher rule is that is strict liability. In absolute liability, no such exception is there, like the vis major, voluntary non-fit injury, other these exceptions are not applicable. That is a Delhi case, Mehta case. That is you go. I do not remember
Yes, sir.
now.
MC Mehta
Uh,
versus Union of India, sir.
Hello.
FC Mehta versus Union of India.
MC Mehta case. That is MC Mehta versus. That is absolutely liable. No exception is there. Absolutely liable. Even if act of God is there. That is a new theory word. Then voidable marriage is that marriage which can be declared void at the option of the agreement. That is voidable marriage. Yet marriage continues. If the aggrieved party doesn't declare the file petition to declare the marriage void, then that will be treated as good. Then right of child, a child born out of void and void of marriage will be treated as legitimate, and the child will also succeed the property of the parents, not of his grandparents. That is, ancestral property cannot succeed, but he will succeed the property of his parents, both father and mother. Then co-personary property inherited by a person from his father's father, that is co-personal property. Co-personals of two, that is there in property inherited. Then dacoity, you are missing a word when 5 or more persons conjointly commit robbery, that is 5 or more persons conjointly commit robbery, that is dacoity. Criminal breach of trust, where a person has been entrusted with any property, he uses for his own use or violating the trust, that is criminal breach of trust. Assemble for dacoity, there is a provision for simply assembly is there, no preparation. Probably 404 words, that is the particular section is there. Simply only section where assembly itself for dacoity is an offense. Then that is another legal disability when period of limitation will run because of minority and insanity of a person. That is called legal disability under the Limitation Act. So go through it with confidence. Okay. Thank you.
I think sir has given you enough of feedback. So only few things that sometimes in some questions uh, don't give extra informations, right, to answering to the point. And in few of your sentences, please be little careful about use of the words. Like I have done this and this thing has been done. So like in grammatically, okay. Although these are not properly, I mean, not so seriously marked, but it's better if you are, I had mentioned this, but exact line what you mentioned, I have not written down. But however, don't give extra informations, and do not, I mean, be very careful about use of words sometimes. Okay. Rest, I think you would be doing exceptionally well. All the best.
Thanks.